Dobry Twardowski. Well, there is a new fad gripping libertarian legal scholarship funded by, of course, the likes of the Cato Institute, namely the libertarian idea of polycentric law. My friend Frank's 2732 in Australia was grappling with the problem of polycentric versus statute law. Check him out, by the way, for some good reflections on this and other progressive issues. I thought I'd add my own critique, keeping it basic without too many pretentious references. Essentially, polycentric law means having different legal bodies of law and legal entities for different jurisdictions, different institutions, and different classes of persons, as opposed to the one-size-fits-all proportions of statute law. To adopt polycentrism would reverse 3 centuries of legal evolution toward equality under the law, which is possible only if there is one unitary body of law under one single jurisdiction. The polycentric theory is the desire to fragment this unity, returning society into a feudal mishmash where all men cannot be equal before the law because there is no equal body of law itself. Law would be subdivided into jurisdictions of caste or localized sovereignty. This is one of the greatest intellectual dangers to the very foundations of a democratic republic, which is the intent. These bodies would be quasi-private or completely privatized, raising the question of getting only the justice you can pay for. Again, not as a cynical judgment on the failure of state law or statute law, but proudly flaunted as an ideal. The fact is that we do have polycentric standards remaining in practice. There are any number of studies showing that in criminal law, punishment differs when applied to a low-status or high-status citizen for the same crime, or a low-status person attacks one of their social economic betters. There's a reason most prisons are mostly filled with the poor and off-color, and not just because they commit more crimes. The definition of crime and the punishment system is skewered in such a way as to apply the same objective standards in a subjectively different manner on a case-by-case basis. One law for the rich, another for the poor, etc. In English law, the wealthy were exempted from so-called common law, but the world has moved away from this precisely because of its incompatibility with rule by the governed, and why any tinge of it in modern law is so bitterly resented. Now, we have retained some polycentric aspects, like diplomatic or parliamentary immunity and so-called Good Samaritan laws, releasing those who have voluntarily assisted others in distress from retaliation should those good intentions go amiss. These, however, are tolerated as exceptions to the general rule of legal equity only because of exceptional circumstances. Being black or poor or a worker are not an exceptional situation, so under a unitary legal system there is no legal basis for treating such persons differently. Being a millionaire or an intellectual is not really an exceptional circumstance either, if one buys into the value of economic opportunity or higher learning as entitlements open to all and not as special privileges for a separate social caste. The modern polycentrists won't go that far yet, but their program would, if implemented, go far to create exactly that condition for the overprivileged. The polycentric legalist wants to free us from the hypocrisy of unitary malpractice by reverting to a legal system of different strokes for different folks. In practice, this seeks to exempt the powerful and wealthy from all liabilities other than what they choose to recognize. Where's the liberty in that for me, or you? The danger is that young ivory tower types glom onto these kinds of fads without realizing where exactly they're being led. Like the young beer hall Aryans of years ago, they assume that special folk laws will privilege them and exclude those fringe elements beyond their law, without stopping to think that it will not be applied equally to themselves either. All legal authority will be interpreted by a private entity, a Führer of some kind, who absorbs all civil law into his private personhood, as judge and enforcer. So doctors would not be judged by common law for malpractice, but only by a court of peers. The same with the judges who foul up in their profession, with corporations who sell deadly products, or destroy the environment, or employ contract child peons. If these separate bodies exonerate them, then we, the common folk under common law, have no other choice but to accept this binding judgment. No libertarian nonsense when it comes to the absolute rule of this kind of so-called law. And of course, these separate bodies would have their own enforcement power over you in any legal contestation. You as a citizen might be hauled before any number of legal regimes with differing norms and values that not even a law professor could keep track of. Or the enforcement might be delegated to a common law court, whose hands are bound to enforce the other court standards. At the bottom of it all, the old dictate remains that all political power, the basis of law, must rest on enforcement, the famous barrel of a gun. As for geographic polylegalism, this is simply the desire to break jurisdiction into small pieces that the wealthy can put in their own pockets, without appeal to a higher court, that might force them into submitting to higher law and give back the sovereignty and wealth they've expropriated. The lord of the land becomes the law of the land under the golden rule of he who has the gold buys his self-rule. This theory is being forced on a number of countries by the U.S., especially those under U.S. imperial occupation regimes, in the form of making its soldiers stand above local law when it violates the rights of those people. This is a reversion to Roman law, as applying to Romans everywhere at all times and places beyond local law, and is quite rightly resented as an infringement on sovereignty. It's why the U.S. is pulling out of Iraq, because the Iraqi parliament refused to grant extraterritorial immunity to U.S. troops on its soil. So one can say that the whole concept of polycentric law is basically to immunize the wealthy and powerful from any mistreatment, any atrocity they might commit outside their circle, to leave judgment to a biased body that will, in 99% of all cases, especially as they apply to the 99% of us, will already have a prejudiced verdict in reserve regardless of circumstances. But if you do something to them, you'll be unequally subject to their retribution. It wants to replace integrated legality not with the hypocrisy of separate but equal, but to overturn all modern law by open reversion to separate and unequal. Honest it may be, but so is cancer. That doesn't make either a desired state of being. Uh-oh, I knew it was time for another knock on the phone. Hello. Lennon, what's up, Vladimir Ilyich? Surely you can't be siding with Hayek or the Cato Institute on this one. Well, but you do. All power, which is the essence of law, comes down to who does what to whom. To believe otherwise is the illusion of bourgeois democracy. So, you would say workers' class justice demands the arrest of all American capitalists and their libertarian mouthpieces, trying them in a special revolutionary tribunal and shooting them all afterward, with no bourgeois hypocrisy about equal justice under one standard of law. I hear you. Glad the Cato Institute gave you a job after that double-crossing bourgeois reformer bastard Gorby ran you out of Moscow.